Hey, how's it going? Welcome back. Enjoy the video. See you at the end.
Motions that have been filed, or what do we need to do today?
Your Honor, if I may, I think my motion to compel is the oldest filed. We filed that back in November. Mr. Olson has filed a motion to compel in January. A motion for spousal maintenance modification in January 29th. A motion as to an advancement of funds, January 29th, and a motion as to the Denali and advancement of funds dated February 28th. And then there are a couple of objections to business record subpoenas. I had filed the objections to business record subpoenas notice of intent that Mr. Olson filed. Your Honor, we are set today for a status conference on the motions to compel. I suggest that we take a half day and I know the court prefers in person unless it's for a status conference, a half day to take care of these many motions filed. And in the event that Mr. Olson and I cannot finish the discovery issues, I just received the summary of documents he indicates he hasn't received from me in his exhibit notebook. I sent him a couple letters, at least one in February, about information I was missing. If we're unable to resolve the motions to compel, I would propose doing those with the half day. Your Honor, the motions that have been filed in January 29th and February 28th, they're going to involve significant matters where we may need evidence. There are going to be, I have a summary from an accountant. Mr. Olson has a summary, a report from an accountant. These are not things that ought to be taken up in a Zoom status conference, 3 o'clock on a Friday, Your Honor.
My understanding, Judge, was when we continued this the last time that we were set for hearing today, we're ready to proceed on the motions. I'm sorry to interrupt you, Mr. Thompson.
I wasn't quite finished, Your Honor.
All right, hey, Mr. Olson, you'll have an opportunity to respond.
Apologize.
Yeah, we were set for a status conference in February, not an in-person. And unfortunately, Mr. Olson did indicate we continued it because my mom was hospitalized and ended up passing away with 2 weeks ago today. So I did request a continuance, Your Honor. Mr. Olson was kind enough not to object to that when I had to go take care of my mom at the hospital. But at any rate, that was not a half-day in-person hearing either. It was once again a Zoom status conference. Mr. Olson has filed a number of motions for this status conference, which I don't think is appropriate to be heard. It ought to be a half day. We take the time, we do it in person, and we do it the way we typically do things, Your Honor. Thank you.
All right, thank you, Mr. Thompson. Mr. Olson?
Well, and obviously, and I apologize for interjecting over Rick when he's speaking, Your Honor. That's not my recollection of it all. The court has set these because we have had a number of motions, some of which have been pending for months now, that the court has set over to get enough time for us to bring these up and to address them. The last status conference hearing we had, which I'd have to go back and look, Your Honor, but I believe it was sometime in either January or December, which it was set for status at that point in time. We moved these over to the last date that had to be continued in order to address these numerous motions that we've had on file. I'm fine with parceling some of them out, specifically the ones that can be tedious and time consuming, such as the motions to compel. Frankly, just to update the court, Mr. Thompson supplemented a lot of the discovery. I don't think we've got anything really of issue with our motion to compel, and I'm fine with passing that along. Or frankly, if it would not prevent us from having to move this yet once again on down the road, withdraw the darn thing. But we need to get moving on it, Your Honor. This case has been pending for over a year. We've had a motion to modify spousal maintenance on file since January 29th. It's now March 7th, which hasn't been brought before the court. And we have the two other motions pending. All of these revolve around funds, money, and whatnot, which, by the way, a respondent has complete control over to the detriment of my client, which is hindering litigation, and we need to have them addressed. We're ready to proceed on everything here today, Your Honor. We spent the time, we're prepared. My understanding is we were set the last time that this was set to be a somewhat extensive hearing where we were going to address as many motions as we have. So we're ready to proceed today. This doesn't need to be moved again. We're going to be getting another date into the end of March, into April, and it just goes on and on and on and on and on. And now's the time to address it. It's time to go, so to speak. So we're adamantly opposed to moving anything. We're ready to proceed here this afternoon. We've got plenty of time. It's 3:07.
And Your Honor, if I may, the invite from the court, I'm looking at it, we're set for a 1-hour status conference that the court submitted. That's what we're set for today. That's what the court, in my experience with this court, what we typically do. Zoom, you do statuses. If we're doing a motion to modify, as our motion to modify, we had to be in person, Your Honor. And that's what Mr. Olson's motions are. They're motions to modify, Your Honor. And
Well,
it's not.
I have this as a status. It was, that's what it was set for in February. I've got an hour. I've got to do an emergency care and treatment case at 4. So that's how I have it on my calendar as a status. If in this hour we can resolve some issues, I say we take advantage of it. If we need to set an in-person hearing, which is my preference on, when we've got multiple notebooks and so forth, we'll do that. But if there's something that we can get accomplished today, I would like to do so.
Your Honor, if I may.
Go ahead.
In listening to Mr. Olson and in my comments, we may be able to resolve the motions to compel outside of a hearing. I may need court intervention on some objections that Mr. Olson filed, but that should not take long. I think we need an in-person half day to address all of these different matters, Your Honor. I don't know what we can accomplish on the Zoom hearing, except it would be as a discovery, but I think we might be wasting the court's time because I think Mr. Olson and I can figure out 80% of it at least, if not 100%, on the discovery issues.
Oh, well, I'm fine with moving the discovery issues, Your Honor. We're still here. We've got 50 minutes. We can at least take even if it's the motion to modify spousal maintenance, we are more than capable of dealing with that over Zoom and handling that this afternoon, so we don't have to continually drag this out and move it to another date, which I'm sure will probably be early to mid-April. We're ready to proceed.
Sorry, man.
Okay.
Your Honor, as the motion for spousal maintenance, that's going to involve competing experts. That is not something we're going to be able to do over Zoom, Your Honor. And that also ties in with the motion to compel and for advancement of funds, and also the denali, Your Honor. We have issues involving the domestic relations affidavit filed by Ms. Yost, and I think she's going to need to be sworn in to go over her expenses. She claims $4,000 a month, every month for attorney's fees, Your Honor, amongst one of several expenses that are questionable. So this is not something that is appropriate over Zoom.
Give me a second to review. And Angela, I misplaced my docket notes. They're buried on somewhere in here. Can you have the ability to print those out for me, please? Now the expert witnesses, what motions were those for?
We disclosed we had an income analysis done of Mr. Yost, Your Honor. That was disclosed on January 17th through Jeff Querin. So the only part of the motion that we have dealt with that obviously is the motion to modify spousal maintenance. If the court would recall, initially when we filed this case, we're the petitioner, we had set spousal maintenance at $9,000 a month. And the court actually called me, this would have been through the ex parte temporary order, inquiring as to when the last year of tax returns we would have had available at that time. And that was 2018, which Mr. Yost at that time had made significantly less than what he had made over the last 3 years that we've averaged. So at the time, maintenance has been set based off of an income of Mr. Yost around $338,000, $318,000 or somewhat. And the report we've had from this income analysis that Jeff Querin has done 7 weeks ago has his income average over the last 3 years at $664,000. So again, that's not brand new news. Again, that report was issued and sent to Mr. Thompson within a couple of days, if not on January 17th. So, I mean, there's been ample time to respond to that. Frankly, if we're disclosing expert reports by statute, Mr. Thompson would have had to have a responsive expert opinion within 30 days of receiving notice of us issuing that report. So that's not been done. We're outside the 30-day window. So I really don't know what the dispute is on this motion with respect to the spousal maintenance, besides trying to continue to delay this matter. So again, we're ready to proceed. It's all argument. There's not any need besides the domestic relations affidavit, which is a sworn statement. There shouldn't be any need to question anybody on the witness stand. This can be done through argument.
Your Honor, and I disagree completely. If we review Ms. Yost's domestic relations affidavit, every single expense that she listed, she deems as estimated. Every expense without a single exception. As the expert report, if I have a reply to their expert report pursuant to the rules of civil procedure, that's 30 days. I can have an independent expert, separate and apart, Your Honor. I have a demonstrative exhibit, which I anticipate. Let me try to be as succinct as I can. We cannot get this done in 45 minutes. Any one of these motions, Your Honor. Any one. The domestic relations affidavit is riddled with, well, they're all estimates. I'm entitled to inquire of Ms. Yost as to what her actual expenses are, because she has not provided a single solitary actual expense to justify any deviation from the court's order of spousal support. None, Your Honor. Everyone's an estimate. And the court cannot make a determination based on pure estimates by the party requesting a modification of her own spousal support award.
But there's no case law to discuss that, Your Honor. Estimates are commonly used because a DRA has to be filed prior to the time of trial. Usually most pretrial conference orders require 10 days in advance of trial or 30 days, depending on the court and jurisdiction you're in. At that point in time, it is very common practice to have the exact amounts put in. Otherwise, you put estimates in. That is something I've commonly done in 15 plus years of domestic practice. And frankly, if we're talking about my client's expenses and we want to get into the analysis on spousal maintenance, it really doesn't matter, because need doesn't have to show. Of course, we're talking about need versus ability to pay. Clearly, there's an ability to pay. But when we start talking about need, it doesn't matter if my client is destitute or has to live or needs the exact amount of money she's requesting by spousal maintenance. It is need as a standard of living. Mr. Yost makes $55,000 a month. So it doesn't matter if my client needs $3,000 a month to live off of, or she needs $9,000 for extra expenses and a standard and a quality of life that she's accustomed to. That is still need. And that's what we're dealing with here. Again, there's been ample time for Mr. Thompson to respond to Dr. Querin's report from January 17th that we provided to him. We are ready to proceed. This has been set on the court's calendar for a number of weeks. We need to get moving on this immediately. There's no reason to have a half day or a day long hearing over motions to modify a temporary order. It's not that complicated.
I'm sorry. And Your Honor, I'm astounded Mr. Olson made the argument that need is not a factor. Need is most certainly a determinative factor as to spousal support. And the court cannot make a decision when not just one or two, every expense is estimated. And it is not for the time of trial. She is asking for a change right now. So the need right now is what we need to determine, not what she may think she needs in a year or two, which I don't even know where she's coming up with these numbers, Your Honor. Most certainly $4,000 a month in attorney's fees for every month. But, Your Honor, we're putting the cart before the horse. I didn't say a day. I think it can be done in half a day. The court does not have the ability. I don't think the court has the ability to make an informed decision based upon argument when there are all of these issues with the documents that have been submitted. We have over 300 pages of exhibits, Your Honor, for a status conference. That is not status conference material, Your Honor. That's a half day in person, as this court's procedure has been throughout this case and the other cases I've been involved with, Your Honor.
All right, if you all can give me just, I'm going to take a short recess to review these docket notes. Give me just a second. All right, we'll go back on the record, same appearances as before. All right, going back through the docket notes. January 14th was the last time we were here. The parties were still exchanging exhibits. I don't think at that time any of these new motions had been filed yet. I think those were January 29th, the date that those were filed. So we set it for February the 10th for a status by Zoom at 3 o'clock. We got the notice about your mom, Mr. Thompson. Sorry to hear about your mother. It was continued for very good reason. again, for status. So typically when motions are filed in between, when we've already got a status hearing filed, I take that as an opportunity to determine, have any of these motions been resolved? Do we still need more time to get documents? I typically don't utilize that as a time to hear those motions unless it's something minor that we can get addressed. So in my mind, I tend to believe with Mr. Thompson here that this just needs to be set so we can hash everything out. Frankly, a lot of reading through these motions, I thought a lot of this stuff would have been resolved already. I mean, these are the types of issues that aren't ones that we typically have to spend so much time trying to resolve, just the exchanging information, making some concessions to help one party get along during the pendency of the case. This case is getting long in the tooth. Where are we at on domestic conciliation?
Parties are in with Richard Samanago. They've got another follow-up appointment. I think they've met with him twice. Got another one in another week. But they're still in the mediation phase of it. It's clearly going to go to an investigation aspect for DC. So I can follow up with Richard this week. We had kind of planned to do that anyway, but I would anticipate probably at least another 3 or 4 weeks before we have anything as far as feedback from him.
All right. I understand, Mr. Olson, you're wanting to get this stuff resolved. I want to get cases resolved probably more than you guys do. But this is a status, and this is what we're doing. We figure out, has anything been resolved? What do we need to do? Well, it doesn't sound like anything's been resolved, that we just need to set everything for hearing. But I want to set an afternoon, and it'll be an in-person hearing. And we'll take up everything that we can that has not been resolved at this hearing.
Your Honor, may we try to set something within 2 to 3 weeks, and literally whatever I need to do to make a time work, I will make that happen. And I've actually got some good availability in the next 3 weeks for things. I mean, it's just something needs to get moving on this for my client's benefit. So I would greatly request that we be able to have something set at least within 2 to 3 weeks.
Well, I know I've got spring break coming up, not next week, but the week after that. I think I've got a criminal docket week, so I don't know if I can do it that soon, Mr. Olson. Angela, when do we have a half day?
Not until April 30th at 1:15.
April 30th at 1:15.
That works for me.
I'm mute, Your Honor. I'm sorry. April 30th at 1:15. Yes, Your Honor.
Okay,
Brian,
let's
is that-
set it there. And I don't know if some of these financial requests for modifications would be applied retroactively if the court does that, but that's something that can be
We've
looked.
requested that, Your Honor.
And I would encourage you all to try to resolve as much of this stuff as you can. Start making some concessions, the parties amongst one another. Otherwise, the expense just goes up. The time we have to spend in court reviewing all of this stuff. A lot of it, frankly, that looks, and I don't mean to downplay it, it looks like run-of-the-mill type issues that typically parties can resolve amongst themselves.
And Your Honor, I will tell you that for the last 3 weeks, I have been very unavailable. So I have given brief responses to Mr. Olson. I will provide him more detailed responses, Your Honor.
And I understand your situation, Mr. Thompson, totally. But hopefully this time between now and when we come back, you all can get some of these issues resolved or narrowed down. obviously, not everything can get agreed to. I understand that. And
Your Honor, may I at least inquire, my clients are, a bit of a hard spot financially, which is ridiculous considering the assets that these parties have available to them. One of the things that we've requested in our motion, one of them was that under the temporary order, there was a savings account through Credit Union of America, I believe, that had about $318,000 in it. And part of our temporary order had that account being split. Can we at least either address that, or the court would grant my client some advancement on property settlement, even if it's $20,000 or something like that, since we're going to be pushing this out till the end of April. I know I'm not trying to downplay $20,000 is a lot of money. It is not a lot of money for the assets involved in this case, and Mr. Yost is in control of all of them. So if there's some just temporary relief that my client can have, and again, I say that in the sense of advancement on property settlement, because if the court orders for her to be awarded an advancement on property settlement of $20,000, it's not that money just goes away and is forgotten. That would be a line item on a marital estate spreadsheet that she's already received that money, prior to the court's final disposition or whatever agreement can be reached if ever it comes to that. So again, with this being April 30th now, before we're going to be able to bring this up again, we would ask for at least some temporary relief that is not an amount of money that there's not cash available to do that. It makes no sense to me that that would be something that would be contested, I guess, because of the financial resources available to the parties.
Your Honor, I briefly visited my client. We have an order that is an advancement on either what Ms. Yost receives in settlement or from a court-ordered property division, that's appropriate. We can discuss an amount. I think Mr. Olson mentioned $20,000. I will double confirm that with my client, for lack of better terms. I just spent 5 seconds whispering to him. But
if you need a couple minutes to do so, do that now, Mr. Thompson.
Okay, I'm just like, that's fine.
Sorry, Judge, were you talking to me?
I was telling Mr. Thompson to take a few minutes to visit with his client.
Okay.
Your Honor, as Mr. Olson couches it, it would be a court order where that is an advance against monies that she would otherwise receive in settlement or from a court order. That's agreeable.
Mr. Olson?
Okay, I'll draft an agreed order, get it sent over to Mr. Thompson. If we can have it, can we at least have the court pending an agreed order, which I couldn't imagine would be anything detailed, that it can be tendered within 48 hours of that agreed order being filed, or we can have it it's got to be tendered within a week of today regardless, and I'll get something sent over to Mr. Thompson.
Mr. Olson gives me a simple order of money.
Okay.
We can get the money transferred within 2 business days. Yeah, by next week sometime.
I'll do that this afternoon then.
Yeah, I probably won't get to see it this afternoon, but yeah.
That's okay.
All right, so that'll give your client some monetary relief in the interim. Any other matters, Mr. Olson, from your perspective, that need to be addressed today?
Yeah, but the court's already told me we're coming back on April 30th, so I understand and appreciate that. Not beyond that, Your Honor. No, sir.
All right, and Mr. Thompson?
No, Your Honor, thank you.
In the order that's being drafted, we probably ought to have something that sets forth the new court date.
For at-day hearing, yeah.
1/15, correct? You're on 1/15?
1/15 in person. Do we need are there going to be additional exhibits? Do we need to set another deadline?
I would anticipate additional exhibits, Your Honor, yes.
Well, then I would hope or request, especially we're going to have expert information being disseminated, that I have no less than 14 days before the hearing, because obviously we're going to want to have Dr. Courtroom review anything that Mr. Thompson provides to us. So
April 16th.
That's fine.
Your Honor, that's fine with me.
Okay, April 16th by 5 o'clock.
Yes, Your Honor.
And that would be for all exhibits, Your Honor?
Well,
Or just
Your Honor, since we've sent notebooks to you, would these just be the supplement? You don't want a whole nother notebook, you just want the additional documents, right?
That would make a lot of sense, just to supplement the notebooks you've already provided.
Yeah.
That would save I think your staffs and you all
Yeah, yes.
Yeah.
time and expense.
That'd be my preference, Your Honor.
All right, that being resolved, anything else, council?
Not from the respondent, Your Honor.
Not from petitioner. Thank you, Judge.
All right, thank you, everyone, and have a good weekend.
Hey, thanks for watching. Don't forget to like, share, and comment your thoughts below. I want to hear what you think about this. As always, subscribe. Peace.